Have you ever shaken hands on a deal and wondered what actually makes this stick? Well, today we're going to trace the entire journey of a business agreement in India, from that simple handshake all the way to a legally binding contract. Let's dive in and see how it works. This is really the core question, isn't it? It's not just about trust or a friendly agreement. There's this kind of legal alchemy that turns an idea into something a court will actually back up. So what's in that secret sauce? To really get this, we've got to start from square one. We're talking about the fundamental building blocks. These are the absolute non-negotiables that give a promise its legal muscle. All right, so under the Indian Contract Act of 1872, for any agreement to hold up, it has to be built on 5 key pillars. First, there's lawful consideration. Basically, both sides have to give something of value. Then, free consent. Pretty simple, right? No one's twisting your arm. Third, a lawful object. You can't have a contract to do something illegal. That's a non-starter. Fourth is capacity, which just means everyone involved is legally able to make a deal. You're an adult, of sound mind, and so on. And finally, there has to be an intention to create legal relations. This is what separates a serious business deal from, say, just promising a friend you'll grab lunch.
Okay, so now let's hop in a time machine for a minute. For centuries, the business world operated on a totally different and, frankly, much harsher principle. All the risk was pretty much piled onto just one side of the deal. The guiding rule was a Latin phrase, caveat emptor, which means let the buyer beware. And boy, did they mean it. If you bought something, it was 100% your job to check it for flaws. If you ended up with a bad deal, well, too bad. That was your problem. The law offered almost no safety net.
And this principle has some seriously deep roots. It goes all the way back to a wild case in 1603, where someone bought what they thought was a magical healing stone. Surprise, it wasn't magical. And the court sided with the seller. Why? They said he never explicitly guaranteed its powers. This way of thinking eventually got baked right into the law, first in England and then in India's own Sale of Goods Act in 1930.
But, times change. As business got more and more complex, that old rule started to feel really unfair and just outdated. And that led to this massive shift in legal thinking, basically flipping the responsibility from the buyer over to the seller. So we went from caveat emptor to caveat venditor, from buyer beware to seller beware. It was a complete 180. The law finally started to catch up to a modern reality. Hey, it's usually the seller who has all the information, right? This wasn't just a change in fancy Latin phrases. It was about rebalancing the scales of justice for a modern marketplace. Now, this shift didn't happen overnight. It came through some really important exceptions that were carved into the law. For example, if you tell a seller exactly what you need a product for, and you're relying on their advice, that product has to be fit for that purpose. Or if you buy something based on a description, it has to be of merchantable quality, actually usable. Over time, these exceptions became so powerful, they pretty much became the new rule.
Okay, so we've got a valid contract, we understand the seller's duties, but what happens when, despite all that, somebody just doesn't deliver? How can a contract actually plan for its own potential failure?
This is where the idea of planning for a breach comes in. And as research from IIM Ahmedabad shows, smart contracts don't just hope for the best. They define exactly what happens when things go wrong, using a very clever tool called liquidated damages.
So what are liquidated damages? Just think of it as a pre-agreed price tag for breaking a specific promise. And under Indian law, it's not some random fine you pull out of thin air. It's an amount that both sides agree on from day one is fair compensation if the deal falls apart. And this is the crucial part. For a liquidated damages clause to actually hold up in court, it has to be a genuine pre-estimate of the real likely loss. Indian courts will throw out anything that looks like a penalty, an outrageous amount designed just to punish the other side. The goal here is compensation, not revenge.
So if you're writing one of these clauses, you have to be precise. You need to be really clear about how you calculated that number and specify exactly which broken promises trigger the payment. And remember, that number also works as a cap. You can't come back later and sue for more than what you both agreed on.
But sometimes money just isn't enough, is it? What if you don't want compensation for a broken promise? What if you want the promise itself to be fulfilled? This brings us to a much, much more powerful remedy. For a very, very long time, the standard solution for a broken contract in India was simply money. Getting a court to actually force the other party to go through with the deal, a remedy called specific performance, that was incredibly rare. It was the exception, not the rule.
But then a huge amendment in 2018 completely flipped the script. Now, specific performance is no longer the exception. It's the rule. The court's default position has shifted to enforcing the actual contract, which makes promises a whole lot harder to just walk away from.
The Supreme Court really nailed this new mindset in a 2024 case. They clarified that while it's not an automatic right, courts now start with the assumption that the deal should be enforced. The burden of proof is now on the person who broke the promise to explain why they shouldn't have to follow through.
Okay, so after this whole journey through legal history, what's the big takeaway here? Let's put all the pieces of a modern contract's life cycle together. It really boils down to a 4-step process. First, you build your promise on that solid legal foundation of the 5 pillars. Second, you understand the modern duties, especially that we live in a seller beware world. Third, you plan for things going wrong by using fair, pre-estimated damages. And fourth, you know that today's courts have a powerful tool to make sure the deal actually gets done. This whole framework, it's all built on human intention and human responsibility. But as we move into an era where artificial